A very good morning to you and good evening, depending upon how you're located. So this is what we're going to do in this session. The first part, I'm going to do some general revision with you on some areas. And then the second part, we will allow you to bring up issues which you may have. So the first part, I will just lock the mic and engage you. When I am done, I will release the mic, have like the general questions and answer forum. Let me share my screen. So, Okay, so as we do, we start with the prayer. Heavenly Father, we thank you for the gift of knowledge and opportunity to prepare for this important journey. Grant us clarity of mind, diligence in study, and humility to learn. Bless our discussions today that they may sharpen our understanding and guide us towards wisdom. We entrust our efforts into your hands, knowing that success comes from you. Amen. St. Carlos Otis, pray for us. St. Thomas Aquinas, pray for us. Mary, seat of wisdom, pray for us. So we would like to revise our knowledge first on two aspects of thought. We'll be looking at defamation and occupiers liability. And when we are done with that, I have some few questions I'd like us to walk ourselves through together. So first of all, as you learned during your Bachelor of Laws days, defamation is a particular uh, area or branch of thought which seeks to protect one's reputation. And reputation here refers to society's estimation of a person's worth, if you like, or a person's character, as it were, not self-esteem. So it's not how you value yourself or how you see yourself as important or someone as of a certain uh, ranking or status, but how society sees you. So, how does society estimate your worth? So, society's estimation of you is what constitutes your reputation, and that is what the thought of defamation seeks to protect. So, therefore, where a person has made a publication of a statement, whether expressed, that is direct, or implied, uh, that tends to lower a person in the estimation of right-thinking members of society, or exposes him to hatred, ridicule, or contempt, then defamation will have been indulging or have crystallized or have been committed. So, what interest does the thought protect? Your reputation, and as you've indicated, your reputation here is not your self-esteem, but what right-thinking members of society actually see you to be. And as you have seen in the plethora of cases, as you learned the area, and if for nothing at all, the recent High Court decision Ankoma against Bedu, I mean, despite whatever the outcome of the appeal is, more importantly, uh, the exposition of the law, which was given by the, the High Court, I think provides a good elucidation or a good elaboration in a very cryptic way what this particular area of the law is. Of course, as well as Kokubako against Canada, Japan. And these days, defamation has become a very big deal in our country, Ghana. So it is worth uh, being interested in it. And of course, it's also been tested before, I think either in 2023, if my memory serves me right. I think there was a question like that. So when it comes to the policy rationale of the total defamation, it is a very fine balance which the law seeks to strike between the need to protect one's reputation and also the need for freedom of expression to be protected so that public interest will also be safeguarded. So, if you look at the High House of Laws decision in Derbyshire against Times Newspapers Limited, this policy rationale for this particular thought area was quite articulated by their lordships that on the one hand, we need to protect people's reputation as to how they are viewed in the estimation of right-thinking members of society. On the other hand, we also need to allow people to be free to express their views, and especially those who use the media and others to be able to allow free flow of information so as to safeguard the public interest. So the principles of law in this area is calibrated along this consideration. How to avoid restricting, freedom of expression or free speech, and at the same time, how to also ensure that free expression and free speech is not carried, to excessive limit, so as to jeopardize people's hard-won reputation. So that is the background. So let's keep that in mind. So how do we determine whether there has been defamation? What is the test? This is not a full lecture, so we're just using a very broad brush, right? Very summary approach so that we just refresh our mind on what the area of the law is. So to determine whether there has been defamation, the test is objective. And why is it so? Because we stated at the very outset that it is not your self-esteem, so it is society's estimation of you, which is being protected. And if that is so, then we are talking about what right-thinking members of society consider you to be or make of you. So the test then is objective. So will the words altered, will it lower the claimant or the plaintiff in the estimation of a reasonable, ordinary right-thinking members of society? So it's not your own opinion. So Simmons, Stretch, and so many other cases remind us that it is what the public, of course, not any public, uh, reasonable, ordinary, right-thinking members of society, when they hear those words, or when those words are communicated to them, will the words actually lower how they view you? That is the point. Again, in terms of the defamatory material, in a sense, it involves the two questions which are at play: questions of law and questions of fact. In other words, whether the words uttered or published are capable of a defamatory meaning on their natural and ordinary sense. So the judge will have to determine that. And again, having regard to the actual circumstances. So two things, as we notice, as to whether the words have the capacity to be defamatory when they are considered in the ordinary natural meaning, that is a question of law, and the judge will have to determine that. But then, if you apply it to the actual circumstances, okay, in terms of time, place, audience, that is the people to whom the words were actually communicated to, and then the public opinion. The words, were they actually understood as defamatory? As whether they were understood as defamatory depend upon a number of factors. The time or the context, the place, the audience, the public opinion, and so on. And as I said, if you look at the earlier decision in the Isankoma against Ekobe, the Taylor, it's also provide a good illustration of that. There's no need for actual damage. Generally speaking, of course, if you are talking about it is therefore enough that the words that have been noted have the tendency or the potential to injure reputation. So liability is strict in a sense once the elements are are met. Then right-thinking members, we are talking about community at large, including colleagues, church friends, and so on. The list is unlimited. So a meaning understood only by a narrow faction may be insufficient unless it reflects ordinary, reasonable members of society. So let us keep that also in mind. Mm. And we're also talking about the fact that when the words are interpreted, they should be given their natural and ordinary meaning. So we're not talking about esoteric meaning, like, meaning which you have to actually have a certain information before you be able to, make sense of it, like innuendos, as we come and talk about later. So, but so inferences as a reasonable reader or viewer will draw are not limited to literal meaning. So it's not only the literal meaning you are talking about, but any inferences a reasonable reader or viewer, of course, including those who are privy to certain background, so that when they hear certain things, they will be able to draw some meaning. So, I mean, it may probably be like a bad example, but just for the sake of easy illustration. For example, when the former Chief Justice case was going on, and then there's a particular sentence, people will say like, the law is the law is the law, or something like that. So as soon as, for example, you hear that, uh, if you are familiar with the processes and the background, you're able to uh, locate or link it to, a particular person or entity, as the case may be. So that's the kind of thing we are talking about. Otherwise, ordinarily speaking, when you say like the law is the law, I mean it's nothing in its ordinary sense, isn't it? But because, the readers or the audience have a certain background, they'll be able to draw a certain inference from it and know that it is this person or that person. So that's the kind of thing we are talking about. So there are various forms of defamation. We have a printed or written defamation, and then the spoken one. So libel, and libel is a defamation in a permanent form. It's either the eye can see it, like including writing, painting, pictures, as it were, and inappropriate, context. It may even extend to audio or video because of definition of writing. Because if you look at the Evidence Act, it's in section 179, writing is, interpreted to include a broad spectrum of things. And if that is the scope of writing, then uh, any of the things which is explained to be amounting to writing, like under the law, if you use it to communicate, uh, a defamatory material, that will be a libel, as the case may be. So if we look at the one section 179, writing and includes handwriting, typewriting, printing, photographing, mechanical or electronic recording, and any other means of recording upon a tangible, like letters, words, pictures, sounds, symbols. So ultimately, audio files, podcasts, video posts, and voice notes stored on a device can amount to a libel, as it were. Because if you look at the definition, it's expansive enough. And libel, as you remember, is actionable per se. That is to say that the law does not require you to prove that you have actually suffered a particular loss or injury. So there's no proof of special damage. And the cases you remember very well. You support for an MGM pictures, what the which was at stake was a film portrayal, and the court took the view that it was not necessary having regards to the circumstances for any moral fault, for example, uh, to have been committed, as it were, and also Monsoon against the Two Sons Limited. There too, a was figure, for example, a was figure was considered as giving rise to libel because it was a permanent form. Well, if you go to cases like the Forester entire, you'll even be told that reading aloud from a document, when understood as such, can be a libel because the permanent nature can still be established. As you also know, have the spoken defamation, what they call like the slander, and it's not permanent; it is transient or temporary. So it's usually spoken words or gestures, or maybe like the sign language, all those things. If you want to appreciate how sign language, for example, could even give rise to a slander form of defamation, when the parties are doing their campaign during the political campaign season, especially the main one, you notice that the major actors and activists, they'll be using all manner of political communication, and sometimes they may not even open their mouth to say anything. They'll use their hands to do certain signs, and it will be communicating a certain meaning, or as it were. So that tells you that even words and gestures can easily give rise to defamation. And that's why I said that is slander, and the law does not. Mm. I mean, the law is not unactionable per se. That is to say that you need to actually prove uh, special damage, unlike libel, which is actionable per se. But there's that kind of, if you like, a straight liability over there, so to speak. So, if you are complaining that spoken words or gestures, as it were, is defamatory, you must plead and prove special damages. That is, you must demonstrate specific, identifiable pecuniary, for example, loss or financial loss or some other things. Have you lost customers? They are all form of financial loss, except in four categories. So there are four exceptions to the rule that slander is not actionable per se, and you must prove special damages. In other words, there are four instances in which slander will be actionable per se, if you like, and you don't need to prove that you have suffered identifiable pecuniary loss. So when somebody make a statement which say that you have a contagious or venereal disease, as happened in the blood wave against rape, like venereal disease like syphilis, okay, gonorrhea, HIV, no, and so on, and chlamydia, and you know them. Yeah. So if, for example, someone makes a statement that you have a venereal disease or contagious disease, probably like, of course, when the COVID-19 also came, you saw how it was, people were afraid. COVID-19, nobody wanted to be associated with it because once it was mentioned that you had it, people want to avoid their company, and it can even affect your employment chances and other association relation. So in Taylor and Perkins, the statement that someone had a leprous sniff was considered as being actionable slander. Or again, on statements which impute or which suggests that you do not have chastity or you are sexually immoral, right? The statements of unchastity or sexual morality, as happened in the Kerr and Kennedy, has been held to be actionable per se. That is, you don't need to prove special, damages. Or maybe like adultery, for example, those statements. And again, crime punishable by imprisonment or felony. That is also so. Somebody said like you are a thief, you're a thief, or you're a pedophile, or you are rapist, things like that. That according to Gray and Jones, and then is Anan Nkuma again, Kevin Taylor, Chukwu and Nkrumah, all would actually be treated as. Then we also have a statement which imputes incompetence in a trade or profession. For example, somebody will say that if not because of me, he wouldn't have gotten any cases. Like Bonsu and Forsen or Professor Adekolu again, University of Development Studies. If someone make a statement which suggests that you are professionally incompetent, such a statement is, if made in an oral form, is a slander, which is allowed to be actionable per se, and there's no requirement to prove actual loss of damages or pecuniary loss, as it were. So to succeed, uh, plaintiff to succeed in an action for defamation, plaintiff must prove that the words are defamatory, that the words refer to the plaintiff, that the words were published to a third party, and then the words are defamatory in natural, ordinary, or innuendo sense. The innuendo sense here refers to like the what do you call like the secondary meaning. Secondary meaning in the sense that because you are privy to certain background information, you're able to draw certain inference, which a person who is not privy to that information will be able to draw that inference. And that could also give rise to defamation in appropriate cases. So it's not enough for you to show that false words which impinge on your reputation were actually made, altered, or written, as it were. You must also show that the words actually refer to you. So the reference is important. You must show a link between you, the plaintiff or claimant, and the particular statement. And again, there should be a third party. So that is the element of publication. If somebody should whisper into your ears that you are a thief, it will hurt you, but if it was only to you and nobody heard it, that does not give rise to defamation. So there should be publication. Publication means that a third party should be aware or should have heard it. That the cases are there, the same cases cited, Paramita Copeland, Simstretch, Yusupov, Lewis and Daily Telegraph, Newstead, Pullman and Hill, Hart and Hart, McManus and Beckham, a lot of them. Then we also have defamation of classes or corporation. That is a group. What you were talking about so far, that individual defamation, like one person, like complaining that someone has actually made a false statement, which impugn his reputation in the estimation of writing members of society. What about a group? For example, can a group uh, complain of having been defamed? Cases like Brown and Thompson and NUPFA against London Express newspaper suggest that yes, it is possible for a class of people to be defamed. And again, we are not talking about the individual members of the class, no, but how society, that is, right-thinking members of society, how they view, for example, such a class or category. Then we also have, can a corporation be defamed? Yes, there is a indication that it's possible because the company or corporations have also got what you call like a brand and so many other things. So its reputation, the reputation of that entity in the mind of right-thinking members of society, and in this case, maybe customers or the patrons of their services that would form some of the context within which we find out whether the statement, for example, made or the writing made about them actually can give rise to defamation of such an artificial entity. What about public bodies? Public bodies through the case law, Derbyshire against the Times newspapers, uh, and then Goldsmith and Bory suggests that it is possible for public bodies to also become victims of defamation. We talk about innuendo, that innuendo can be a way of saying that the complainant or defendant has actually suffered defamation. So, what is innuendo? Innuendo uh, simply refers to a subtle or indirect statement which may be suggestive or disparaging and conveys a meaning not explicitly stated, but it is understood from the context or the tone or the shared knowledge. So the statement made on the face of it is nothing, but because of the context, the background in which it is made, or because of the information or the knowledge which the audience have before this particular statement, they are able to actually derive a secondary meaning or extended meaning from it. And the secondary meaning per se, if you do not have a certain background information, it will be nothing. But if you have a certain background information, that can give rise to what? Defamation, as it were. So we have the true innuendo, that is that which can actually come about because the words on the face or as spoken do not appear to be defamatory, but they acquire a defamatory meaning when read in the context of certain external facts or certain outside facts, like from the statement itself, and those facts known to the audience, when they hear this statement, they're able to actually derive a certain meaning, and which meaning, uh, which if it's false, is definitely like defamatory of whoever is speaking about. Yeah, so you remember, I'm sure all of you at this stage will have read Cassidy against Dari Mirror newspaper, and then Fulham and Newcastle Chronicle. There are a lot of these cases when it comes to defamation. We also have like the false innuendo, that is that the one which will not actually uh, give rise to uh, defamation because it's popular. Then when it comes to advertising too, you see how, especially, you remember, uh, I'm not talking about, if you examine like advertising like closely, particularly sometimes maybe like someone has, let's say, two types of like milk. How they can do an advert and let a particular product, for example, appear to be performing poorly, like in a particular sense, how it is presented. Now, when you look at, based upon how you know the other products and the other certain background, it may probably suggest to you that uh, the maker of the advertisement, for example, is making a false statement which attacks the brand or the reputation of, let's say, a particular company, as the case may be. So look at the trolley against Fry and Sons Limited. What about vulgar abuse? Uh, Bad words which are spoken. Bad words which are spoken uh, generally not actionable. Uh, for example, if someone like, just say, I'm not talking about customer law, we are going to customer law, we're not talking about the Ventura and Redua sort of situation. But at common law, vulgar words per se are not actionable unless you can bring them within the four exceptions that we saw to slander. So let's keep that in mind. But where we have an insult which have been written, certainly, unless you can bring uh, the defenses, maybe truth and other things, otherwise, the insult definitely will contain some falsehood. And since it is reduced into writing, it becomes like a libel, and that can be actionable as it were. So if you look at the cases like Benson and the West African pilot, is a Nigerian case. Now, customer law too, we have our way of dealing with defamation, and so where uh, you know words are spoken, all of you know the uh, Wenchuan and Redwa, the vulgar word which was spoken, and depending upon the particular uh, customary, community, certain utterances may be actionable, and that is why we have cited like the course that depending upon the personal law, you take, a certain community and you say certain words, within that particular customary community, that may actually not be anything, but in another customary community, it may be offensive. So that one will vary from customary community to another. When she and read increment menus, I will not repeat the unprintable words which was spoken there. So anytime there's an issue of defamation, as we know, if the statement is true, no matter how painful it may be, truth is truth. And that is why we are told that truth is a complete or absolute defense. Because if someone has said something about you and it even lowers your reputation, the right thinking members of society. But if what has been said is true, the truth is the truth. Yeah, so I'm sure remember Kwaku Bako and Kennedy Japon, those type of cases. So the truth is truth. So truth is or justification to the defamatory complaint. Then you also have like the privilege. You have like the absolute privilege and the qualified privilege. So let's say that the 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 president, or yeah, let's take him like the parliament. Parliament, for example, in the course of making debates, have made a statement about you, which is false. Can that give rise to defamation? Can we sue members of parliament for utterances that they make in the course of parliamentary debate? Yes, what's the position of the law? There's a direct answer. So what's the position of the law? Okay, let's take Ibrahim. Ibrahim.
Thank you, my Lord. You are most privileged for your good work.
Okay.
I think Parliament is being immune from whatever it does in the course of their business or their parliamentary work, as provided under, I think, Article 115, insofar as it is in furtherance with their parliamentary procedures. Whatever it does is a closed book. Thank you, my Lord.
Right, thank you. What about judges?
It so applies, my Lord.
Okay.
Under Article, I think 127 and 127.
Okay. So what
Thank you, my
about
Lord.
executive communication, the government?
Yes, same applies under Article 57, I think 57, 4 and 5.
Okay, good. Yes. What about qualified privilege? Any example
Qualified
of
privilege,
qualified privilege?
yes, there is to some extent, in as much as what has been said is in line with what is in the public domain or what is the reality, then I think one will be justified from any liability arising from what he has spoken or what he has said.
Okay. All right. Thank you. Yeah, so qualified privilege, or what we call the conditional privilege. It's also a defense, but unlike the absolute privilege, it's not like a complete defense. That is to say that it can be set aside or can be defeated if the plaintiff, the victim of the defamation, can prove malice or bad faith, as it were, on the part of the maker of the statement. If he can prove that, then that can defeat that. So the reason for this qualified privilege is that there are some situations in which the law recognizes that it is necessary for certain people or certain persons to make certain statements or to speak. So therefore, if they do not speak, it is not in the interest of the public. So what are some of those? So where the defendant or the maker of the alleged defamatory statement maybe has a legal or social or some moral duty to disclose or communicate information, and also the recipient has a corresponding interest in receiving it, then, for example, like reference, you want your employer to write a reference about you to your former employer to write a reference to you about to a new employer, as the case may be. So here, the employer has a duty to write candidly, but so if he makes a statement which maybe appears to be false, it may well be that the certain premises have been made, and then a conclusion is reached. I mean, you, the plaintiff, like you being, let's say, the former employee, you think that such a conclusion, for example, is not fair, and then you think it's false. So long as there's no malice, and when everything is considered in its entirety, maybe it was like a genuine statement to communicate what he thought needed to be communicated by way of reference, the law will protect the maker of such a statement, as it were. In the same vein, like maybe you have like the members of association or groups, and it's necessary to communicate matters of common concern. Qualified privilege will be extended there. When journalists are reporting proceedings from parliament or proceedings from court, they also enjoy qualified privilege, so long as they are fair in their reportage, they are accurate and without malice. So if they have reported accurately, but sometimes the accurate reporting may be a reporting of a something which is false, so long as uh, circumstances considered suggest that they were fair, there was no malice, as it were, then they are protected. So these are some of the ways in which the uh, qualified privilege and absolute privilege actually work. And we also have like of course, the same thing relates like the fair comments, and is something which is enjoyed especially by the editorial opinions or the media. Of course, not only them, but if we look at the case law, they enjoy that often. So where there's a, let's say, editorial opinion, for example, okay, is rendered, and you are hurt by it. If the information which constituted the context within which the opinion was held, and what is being commented on is for the good of public or society, then the maker of it will be protected. So to really benefit from this fair comment, the statement must be an opinion or inference, not an assertion of fact. So if you make a statement and you let it appear that you are asserting a fact, then you cannot take advantage of the defense of fair comment, because fair comment must relate to an opinion or an inference. So if, for example, you say that a particular um, politician is, for example, corrupt, that is a categorical, assertion of fact. But then if you say that a particular, politician appears to be corrupt, that one you may be able to rely on fair comment if you have information which enable you to make that opinion. Of course, the comment must always be based on the uh, facts which are true, or if not true, they are privileged. So if the information is privileged, and on basis of that to make certain expression of opinion, then you can take advantage of a fair comment. And again, what you are commenting on must be something which the public has legitimate interest. So it must be something of a matter of a public interest. So if, for example, you express opinion about how the fight against Galamsey either is going well or is not going well, and the water bodies are still, looking red and things like that, and maybe certain individuals who are responsible for it, you want to say that they haven't done what to have actually ended the problem. Now, if you express, a statement like that, that could be taken as like an opinion, and this opinion too is situated within matters which are in the public interest, and you may be able to take advantage of the defense of fair comment should it even happen that uh, you potentially, defame someone, as it were. And of course, there should also be absence of a malice. If malice is present, that is, if you are actuated by spite or ill will or improper motive, rather than a genuine intention to express an opinion, you will not be protected by the law. So if the plaintiff or the claimant can show that when you made that so-called opinion, you were, actuated by ill will or something like that, then you'll not be protected. So let's take note of that. So if someone said that what is the difference between fair comment and privilege? Well, privilege, be it absolute or qualified, as we have seen, protects communication on certain occasions or in certain specific situations, as you have seen. For example, like Parliament and so on. But fair comment protects opinions honestly held. And the focus of the fair comment is the content of the statement, which we have said it should be opinion and not facts. But the focus of the defense of privilege is the occasion in which the statement was made or the context in which the statement was made, rather than whether it is fact or opinion. But with respect to fair comment, as you have seen, uh, where malice is present, the defense of fair comment will collapse. It will not stand. You cannot rely on it. Now, with respect to privilege, malice will defeat qualified privilege, but not absolute privilege. So for example, a judge writing a judgment, it says certain things. And recently, there's a decision by the Supreme Court which has brought up this issue as to whether there can be what you call judicial defamation, uh, conceptually speaking. Well, there's a school of thought who says yes, and then we have a school of thought who says no. But I think that the common law has not changed, and the Constitution too does not appear to have actually exposed judges or authors of judicial opinion and ruling to the potential of being held, accountable for the truth of their uh, writings through the common law actions of defamation. So I think that the absolute privilege still extend to judicial writings and opinions. So where uh, there has been defamation, remedies available, the monetary compensation by way of general damages, and general damages vindicate reputation, as we have seen. General damages will actually apply to those situations where we say that the defamation is actionable per se. There's no need to prove any specific loss. And then special damages, that is actual financial loss and so on, will have to be proved if it is not actionable per se, as it were. Aggravated damages may also be claimed where malice or oppressive conduct, for example, can be established. And then exemplary damages, that is punitive, may also be awarded depending upon the circumstances, especially where you can see that there was actual effort to damage someone's reputation in a very injurious way with all the malice and everything present. The court may award a hefty fine as exemplary or punitive damages. Injunction may also be a remedy, especially where the defamation is ongoing. Okay, that is ongoing, and sometimes apology can also be a remedy, as it were. Okay, so let's look at just the facts of Anas and Kennedy Japan. I just got like the brief, but the full judgment has gone round, which I'm sure you've read. And as I said, not so much about the decision, because as you know, the Supreme Court has had to interfere with that decision when it went there. But the statements or the comprehensive review of the case law, what the judge in his judgment, I think, provide a useful and quick revision for you. But in terms of the factual background, as we know, the plaintiff is a supposed investigative journalist, and he saw 25 million Ghana cedis damage for libel against Kennedy Japon. You know him, so I don't need to speak about him, who had uh, accused Anas of multiple acts of corruption, blackmail, extortion, murder, fraud, land grabbing, and other criminal conduct on various media platforms. So this was the complaint uh, against, or the background of the case. So the Anas, that the plaintiff, claimed that the defendant had made numerous public statements between May and July 2018, among other things, falsely portraying him as a thief, a murderer, a fraudster, blackmailer, corrupt person, tax evader, land guard, child molester, and so on and so forth. An abettor of the murder of J.B. Dankwa Edu and killer of the Chinese nationals. It was also alleged that the statements were defamatory in both their natural meaning and by innuendo, and this damages local and international reputation as investigative journalists. He sought to rely on recordings, on pen drives, parliamentary records, and letters from the Attorney General showing he supported prosecutions. So this was the plaintiff case. The defendant's defense was that he admitted making the statements. Yes, I said all that, but argued that the statements were true, factual, or fair comment on matters of public interest. So he claimed Anas engaged in corrupt investigative methods by taking bribes and shielding suspects, and that he relied, heavily on videos. So the defendant relied on a video called the Who Watches the Watchman, which allegedly showed Anas confessing to receiving bribe in a gold scam case. So the defendant asserted his constitutional duty as a legislator or lawmaker, an anti-corruption crusader to expose misconduct. So we're saying that yes, all the things he's saying, I said, but this is the reason why I said it. So issues before the court were whether the words were capable of defamatory meaning, whether they were defamatory of the plaintiff, and whether they were justified or fair comment, and whether Anas was entitled to damages general aggravated. And if you look at this configuration of issues, typically when you have a problem-based question, I mean, these are likely to be the outline which you may have to also use. So the court applied the common law, defamations we'll be discussing, and with respect to the publication and reference, the defendant admitted making the statement that yes, they clearly refer to Anas. So the plaintiff did not really have to prove that they were referable to him. That was not in dispute. So we came to the capacity or whether the words were actually defamatory. That was the crux of the matter. And for that one, the words like thief, murderer, corrupt, blackmailer, and so on, were they capable of defamatory meaning? Well, the court made some findings that the goose cam video, which Canada Japon, the defendant, relied on, the court found it credible, and Anas was shown plotting with suspects and prosecutors and confessing to receiving bribes. The court held this proved Anas engaged in bribery and corruption, and that justified the defendant's description of him as a corrupt, criminal, blackmailer, extortionist. Now, with respect to the other exhibits, the courts also realized that yes, the documents which suggested Anas plotted to entrap foreign leaders, including the Prime Minister of Ivory Coast and Ghana's president. And of course, the court used a very strong words that this amounted to investigative terrorism. And the court of the view that the defendant was justified in criticizing Anas. So ultimately, the High Court held that the defense of justification and fair comment succeeded in respect of the major allegations. And that I would like to take your view on, regardless of what happens later on the Supreme Court, but just on the facts, I'd like to take your view whether you think that based upon what you have been learning, and we're talking about whether within the context of the facts of the Anas and Canada Japan, the defense of justification and fair comment should have been successful. Yes, what are your thoughts? Yes. Do you agree that the defendant could successfully rely on fair comment as the judge upheld in the judgment? Are we together or you are sleeping and I'm sitting here alone? Okay, Francis. Yes, Francis. Francis, you can open your mic. Just click on can open your mic. Oh, can open your mic.
Okay.
Mm.
Good morning, my lord.
Good morning.
Yeah, so I think that the decision made by the judge that the statement was fair. Yes, for academia purpose, I may agree, but to some extent, I may disagree with the statement because if you follow the case, I think the defendant was not able to adduce any evidence to the contrary that all the statement that he made was true or it was factual. But I think that's why when the plaintiff dissatisfaction with the decision of the High Court went to the international court, the court was able to rule in favor of him because the defendant was not able to need any evidence to adduce to that fact. That's my take. Thank you, sir.
Okay. All right. Okay, so let's take this question. And I want all of you to bring your mind to it. Kwame is a popular radio presenter in Accra. Okay, maybe let me release the mic so that will be there for you. Kwame is a popular radio presenter in Accra. After heated political discussion on air, the following events occurred. After the show, his co-host, Kojo, upset by Kwame's comment, angrily raised a chair as if to strike him. Kwame instinctively ducked in fear of being hit. Kojo then slammed the chair on Kwame's shoulder, causing a bruise. In the course of the altercation, Kojo grabbed Kwame's mobile phone from the studio decks, smashed it against the wall, saying, "Let me see you tweet again." The phone belonged to Kwame personally. Later that evening, Kojo went on Facebook Live, holding up a newspaper photo of Kwame, and told viewers the following: "This man is a thief who has been stealing sponsorship money from our station. He has AIDS and should not be allowed near children. He sleeps with married women to get favors." Thousands of viewers, including some of Kwame's colleagues, watched the video. Kwame sues Kojo in the High Court for assault, battery, trespass to chattel, and defamation. Yes, Olo try. Will anybody? Yes. So will anybody attempt to answer for us? Yes. Oh, somebody say, let me see. Okay, so
But my lord, please, we can't see the whole question. It's like if you can.
you can't see the whole.
Yes.
Okay, let me see. Just a minute. Let me see. Hmm. Can you see now?
Yes, my lord.
Okay.
Yes.
Good morning, my lord.
Good morning, Nancy.
Please, if I understand correctly, you've already provided the areas assault, battery, trespass, and
Yes.
defamation. Yes. So, particularly if I want to pick assault, I will need to identify what will constitute assault in the question and discuss assault and its elements. I don't know if
So yeah,
that's
so
the
help us, right? I will
okay.
just in points. Yes.
Okay. So I'm picking assault and I'm looking at in thoughts assault defined as apprehension of immediate contact. And then I'm looking at the second paragraph after the show, his co-host accepts Kwame's comments and really raised a chair as if to strike him. So that, I don't know, that paragraph there up to the point where of being hit, I don't know if that's where it will constitute an assault. And then because when per the definition of assault, there should be an apprehension. It doesn't necessarily have to be fear, but you must have the ability. The person must be able to predict that you can actually cause the harm on him. And then, yes, so the raising of a chair as in Morton versus Shopee will constitute an assault here. I don't know if, yes. And
Yes,
then,
Nancy.
yes. And then also, if I can pick, I don't know if I'm to take only one or I can take
Oh no, you
battery
can
and
take as much as you're waiting.
okay. So I'm picking battery here, and I'm see from where he almost struck him with the chair. I'm looking at then Kojo slammed the chair on Kwame's shoulder, causing a bruise. So per the elements of battery in thought, direct physical contact, either with his personal body or with any objects like the chair that he used will constitute battery in thought.
Okay.
So yes, I don't know if I'm on the right path, but yes. So from the second paragraph, you can pick assault, you can pick battery, and then
Have you cited? I haven't heard any cases.
for the assault, I'll go for Morton versus Shopee, and then for the battery, I'll go for Miller versus AG versus Attorney General. And then because he used an object, I will also go for Stanley versus Powell. Yes, because he didn't use his hand or his body, he used an object.
Okay.
And then he actually had the intention. So I'll go for yes. So, but basically that's it. I don't know.
All right. Yeah, you are not doing bad, Nancy. You're not doing bad. Yes, Francis.
Okay, so thank you, my lord, for the opportunity. Yes, so I'll first of all also discuss the thought of assault and battery. So here, I'll first of all talk about battery by using the case of Miller and Attorney General. So
So
to
what are the
establish.
principles?
Okay, so the principle is that to establish battery, the claimant must prove that there's an instance of a direct act which is made voluntarily with accompanying state of mind leading to physical interference with the body of an aggrieved party. So that was what the court said in the case of Miller and Attorney General and the battery. And the claimant or the defendant must not have any available defense, specifically the defense of consent.
Okay.
Now, looking at the paragraph, if we look at the case of Stevenson versus Myers, in this case where there was a meeting which was being chaired by the claimant with his fist, when there was a heated argument that if care is not taken, he will hit him, and then they separated them. The court said that one also constitutes assault. So coming back to assault, with the exception of the physical interference or putting imminent
Francis,
battery or fear into the
can you
person,
speak? Yeah.
all the elements, and apart from the physical touch. Hello, Manuel, please, can you hear me?
Yes, I can hear you now. Yes.
Yes, so what I'm saying is, by also discussing assault, I can also use the same case of Miller and Attorney General, and all the elements of battery may establish apart from the physical touch or the physical interference, and where there is imminent battery or fear or apprehension into the claimant, then assault may also be established, as was said in the case of Miller and Attorney General.
Right.
And here too, the defendant may not have any evidence to rely on, any defense to rely on, specifically defense of consent. So looking at the question, by applying the elements that have established supra, I can deduce that yes, after the show, where Kwame, who was being upset by making that argument, and then Angry raised a chair as if to strike him, shows clearly that after the show, his co-host, okay, so Kojo upset by Kwame comment and Angry raised, so Kojo may be liable for battery, and he may also be liable for assault in that case. So now, so I don't know whether I should proceed to the trespass to charity and defamation aspect.
Yes, proceed.
Okay, so let me deal with the defamation. So before a party or a claimant can be successful under defamation, yes, as you rightly taught us right now, there must be a defamatory statement which may be published, and then it may be direct to the claimant, to his reputation or damage whatsoever. And the defendant may not have any available defense, specifically the defense of, and the defendant may not have any available defense, specifically truth, justification whatsoever. Now, with regards to this kind of defamation, I can say that it is an indirect defamation, specifically innuendo. And the case of Miss Cassidy versus Daily Newspaper also established that. So defamation too may lie here. Now, concerning trespass to chattel, yes, you could see that okay, for the chattel, I think let someone also deal with the chattel. Thank you, sir.
All right, thank you. And that's a good effort. Yes. Yes. Who will continue for us?
My Lord, this is Emmanuel. Good morning.
Good morning, Manuel.
Yeah, my Lord, just to, I think they've largely talked about the assault, battery, trespass to chattel. So just to talk a little on the defamation that my brother ended on earlier. Humbly, I want to depart from the Innuendo, rather looking at the fact that it was after the fight that he went on Facebook Live. And from what we've discussed earlier, we can see that I post on Facebook Live. He has there is some kind of slander there because he was making spoken words, and then also holding up a newspaper photo of Kwame with those total viewers where there's a statement that he is a thief who has been sponsoring people. He has HIV and AIDS. He sleep with married women and then to get favor, and then all those 1,000 viewers. So that has become actually a record that it can be seen and can be voted for. So at the end of the day, it will not really be an Innuendo, but it will rather be a slander at the same time, a libel. So there will be the action of defamation will sort of largely. I so submit.
Right. Thank you very much. You've all done well. Means you are poised for action on 12th September. Good. So, yes, as they rightly pointed out, no, was Kwame assaulted when Kojo raised the chair, and I've told you, like, you don't need to be writing no issue rule application, although some will do that, there's nothing wrong, but just for purposes of teaching. So as Nancy, Francis, and the Mikey, the last person, pointed out, assault is any act causing another to reasonably apprehend imminent unlawful force. So there should be direct act. There should be apparent ability. That is, there should be evidence of ability to carry into action the threats. And then there should be reasonable apprehension, voluntary act, no consent possible. So the cases are many. You can use the R and St. George or Blake and Banner, Stevenson and Myers, Scott and Shepherd. Of course, Scott and Shepherd, that's for battery because there was an natural contact. But as you rightly pointed out, when it comes to battery and assault, the only difference is that, as someone will say, that assault is incomplete battery, if you like. And then the batteries are completed also, but don't go and write that. Just trying to let you know that all the elements are the same, except that in assault, the unpermitted contact is actually lacking. And mere words, as we know, cannot give rise to assault. The words must be accompanied by action or what you call the apparent ability to carry the threat into force. Aaron Wilson, Stevens and Myers, and so on. And then Tuberville and Savage, if you remember that case, if I had not been for the assizes, I would not take this statement word from you. And then he attempted, no. Yeah, so Kojo raised the chair in a threatening manner, no doubt. Kwame Dak in fear. So, and this created a reasonable apprehension of immediate harm. Kojo was physically able to carry out the threat, satisfying the eminence. Despite the fact that there was no contact, but the threat, like he was able to carry out like the threat as the circumstances show, and the elements of voluntariness, and this is a positive act. It's not omission. They're all present, and certainly the fact that Kwame Dak in fear suggests that he did not consent. So Kwame has a strong claim for assault. Now, you notice that I think 2 years or so, there was a question similar to this. Then the other one, the battery was Kwame battered when Kojo struck him with the chair. the principle that we have outlined apply. Mutatis mutandis just suffice to recap that battery is the intentional or negligent application of force to another without consent. So there should be a direct act which should be voluntary. There should be it should be like intentional, as it were, and then there should be physical contact, absence of consent, and then of course positive act. Fagan Metropolitan Commission, Police Commission, then Collins and Wilcock, Ince and Wiley. All those are applicable. And then we also know that trespass, of course, battery being a trespass is actionable per se. There's no need to prove damage. All that suffices is that there was an unpermitted contact with one person's one body, and the person should be able to see as whether any injury was suffered or not. That's beside the point. So, in the instant case, Kojo deliberately slammed the chair on Kwame's shoulder. So there was a direct, voluntary, intentional act, physical contact occurred, and then there was no consent, and this is also not a socially acceptable or privileged contact. So that will not apply if you look at the circumstances. So Kojo cannot, put up that defense. Of course, there was an injury or bruise, but as we have indicated, and as the law is not a requirement to establish liability. So on that basis, Kwame can successfully claim for battery. Now the trespass with chattel. Was Kojo liable when he smashed Kwame's phone? Transfers to chattel is also like a trespass like that we saw in the case of battery and assault. So it's direct intentional interference with another's chattel without consent. I remember examiners indicate that when a question like this came some time ago, I think a number of students did not do justice to the trespass to the chattel bit of the question. So it's also actionable per se. There's no need to prove actual damage. And there should be direct, voluntary, intentional physical interference, and a lack of concern, just similar to the trespass to the person. So if you look at this situation, the facts, no doubt, Kojo directly grabbed and smashed Kwame's phone. The phone belongs to Kwame, and Kwame never permitted the Kojo to have it, so Kojo just was on the floor of his own. So Kwame had possession and ownership, and Kojo's interference was voluntary and intentional. Certainly, there was no consent. So even if Kwame does not prove repair cost, the slightest action, as we know, suffices, and Kwame can maintain a claim for trespass, and with maybe some consequential damage for destruction of the phone, as the case may be. And defamation. Do Kojo's Facebook live statements constitute defamation? So as we be discussing, defamation is the publication of a statement that lowers a person in the estimation of the right-thinking members of society. The cases are many, including Pamita and Copeland, Sim, and Stretch. We know libel is a permanent form of defamation. And because of the definition of writing under the Evidence Act, one could even argue that audio or video is also a libel because the element of permanent is what is permanence is satisfied. So if you look at the elements that we are told that the words must be defamatory, the words must refer to the plaintiff, it must be published to a third party, words must be understood as defamatory in their nature, their natural meaning, or innuendo, as before explained rightly. And all the discussions that we did, the principles are the same as we've repeated here. So the statement made online, yes, certainly they satisfy the requirements that we have identified, and they can be treated as in some respect as a libel if you are going by the position that writing has been given an expanded definition under the Evidence Act. But then the content accused Kwame of what? Of theft. Is social, then of course it's also apart from you using the standard definition of writing to make the libel, you can also argue that it's also a slander, as the case may be. Now, what is important in a situation like this is that you should be able to state the principles correctly. Then when it comes to the application, a lot will depends upon the arguments, that you make. But in terms like the statement made, the content, Kwame is accused of theft. That is a crime. So if we are going by the slander, which is actionable per se, certainly all these are actionable, per se, and there's no need to prove any damage, assuming it's even a slander. And if you say it's a libel, then it's pretty straightforward. Again, it refers clearly to Kwame, because we are told that he held up like a newspaper photo, and the element of publication is also satisfied. Because Facebook, you have many people watching at the same time, or not too long even after that. And Facebook material, unless the maker takes steps to have them deleted, otherwise they are kept also for some time. So meaning that so many people can be having access to them. In no time, it may even cross more than 1,000 people, as it were. Well, Kojo, can he plead the defense of truth? Well, from the first, it's not likely. What about fair comment? If you look at the things that he said, we cannot say that he was expressing opinion. And where you are making factual assertions, then fair comment will not avail, as you know. And privilege too will also not apply. So it appears that all the elements of defamation are satisfied. Let's move to
My Lord,
yes.
just a quick question, if you permit me.
Yes.
Okay, so my question is that from the fact we were told that he was holding a newspaper which has the picture of the claimant on the front page, or the photo of Kwame on it.
Okay.
Assuming these words were actually published by the defamatory statement that we are considering, assuming they were published by the newspaper, where he, Kojo, went on Facebook Live showing the same paper to the 1,000 viewers that are viewing his Facebook Live. In this case, he is actually republishing
Yes.
what the paper has been a paper have already published against Kwame,
Yes.
will such actions also
The
will
defamation.
such acts also be actionable
Yeah, okay,
under the
good.
thought of defamation?
Yeah, every publication is a fresh defamation. So that is the position. Every publication is a fresh defamation. So it doesn't matter that someone has published it and you are republishing. Yes, so, and that's my view.
All right, thank you.
Yeah.
I'm grateful.
Good. So let's look briefly at the occupiers liability, then we look at some general questions in all the 6 series before, if we are not tired, we go. As I keep telling you, nobody has told you which area the questions will come. So it is prudent that you quickly look at everything so that uh, wherever the question comes, you will not be found wanting to be able to acquaint yourself reasonably. So occupiers liability, another thought area. It's very important and interesting area of thought as you have learned long ago in your LLB. So we are looking at the premises like a place, being the house or wherever, a premises being there, and you go there or someone goes there, and then the person gets injured or the person gets a problem. Who should we blame for the injury or the problem the visitor to the premise has actually suffered? Should the owner of the premises be held liable for all the unfortunate things which happen to whoever comes there? Is that fair? Or should the law draw a line and say that for certain type of visitors, the owner, you have obligation to ensure that nothing ever happens to them, otherwise you'll be held liable? Or it should be every visitor? So that is what we are looking at. So conceptually, an occupier is one with immediate supervision and control over premises, or the power to permit or prohibit entry. So that's what in the sermon on top, that's how they define it. So if you are you may not necessarily be like the owner, not necessarily, but you have like the immediate supervision and control over the premises, and you have the power to determine who comes onto the premises or who does not come there, then you are an occupier. That was how, originally authorities like Salmon or Harvest and understand who an occupier is. But in cases like Wheat and Lacon, there's some sort like refinement of the definition, and the case law tells us that an occupier is one with sufficient control of premises, that failure to use reasonable care may result in injury to lawful entrants. He need not have exclusive control of physical occupation. And the case will indicate that there can be multiple occupiers, as it were. But in terms of our learning, the core principle remains that liability arises from occupational control, not ownership. So it's not just the owner, but someone who has control over who actually occupy or who comes to the premises or who does not come there. He can have liability. So how do we determine whether a person has, really occupies a place in terms of occupation or occupier? So occupation may extend to control exercised by caretaker, servant, or agent. So Pegler and Craven will tell us that. So if you have your agent or your caretaker or servant on the premises, it's as good as you being there for purposes of determine whether you are the occupier for an occupier's liability determination. And for that matter, in Harris against the Birkenhead Corporation, a local authority became occupier of a derelict house once it served notice of possession, even without physical entry. So even the local authority having served a notice of possession, that was treated as being an occupier. So that if anything happens to anybody who goes there within the appropriate parameters, liability could actually be fixed on them. So the point to note is that for our exams, we are talking, what matters is control of the premises, not ownership or being physically present. So control is that which determines whether you are an occupier for purposes of occupier liabilities law. And I want you to be interested in this because I remember Law Reform Commission started a project to attempt and get occupiers liability law passed for Ghana, but of course that project is still on the drawing board. So I think there's a question as we discuss later, which I put down there. And the question, the question is this. The government of Ghana is considering introduction of a bill on occupiers liability in Parliament. Currently, liability of occupiers is governed largely by common law principles inherited from English law and supplemented by Ghanaian case law, with no dedicated statute codifying the duty of occupiers. As a legal research officer in Ministry of Justice, you have been instructed by Honorable Attorney General to prepare a memorandum outlining key matters that proposed legislation on occupiers liability in Ghana should address. So those are, it's like a typical question which you can, for example, have an occupiers liability in view of the attempt to legislate on that particular area. So let's quickly refresh our mind on this. So what can be occupied, or what is a premises? Premises for purpose of occupiers liability include both fixed, movable structures and immovables, as it were. And then liability depends upon so houses, taxis, houses, ships, aircraft, gangways, except that when it comes to some of these other types of premises like buses, ships, aircrafts, and so on, there are special legislation which provide for safety issues. So it's not so much of importance as like a immovable property or real property. So liability depends on control of the premises. Unlike negligence, where liability can follow after losing control of a dangerous chattel, as it were. Then we also have to know types of visitors for purpose of occupiers liability. We have lawful visitors, and who are those? Visitors who have the occupier's express or implied permission to be on the premises. So they are not there on the frolic of their own, either expressly or impliedly. The occupier of the premises has actually permitted that they should come there. So who are these lawful visitors? One, contractual visitors, like those who come into the premises for contractual purposes, like to come and either do installation or do some fixing or do some business, as it were. So for those contractual visitors, the occupier has implied warranty that the premises are reasonably safe. So it's implied that you are showing them that the premises are reasonably safe. So let's keep that in mind. So try and get 1 or 2 cases for each of these categories. Then we also have invitees. Invitees are common business interests with occupier, like maybe your customers or business visitors or social friends. They have come there because of the the common business interest they have with you. So for them, the duty imposed on you as an occupier is to exercise reasonable care to protect them against unusual dangers. Unusual dangers here are talking about dangers which are not obvious, dangers which are not customary or discoverable reasonable care. Dangers which are such that unless you are told, you are likely to fall into it and you not even know. So those type of dangers, the occupier has obligation to ensure that he provide protection to these invitees against such unusual dangers. So here to know at least 1 or 2 cases. Then licensees. Licensees are those who are on the premises with permission of the occupier or without material interest to the occupier. Maybe like a social guest or tolerated users. So for them, they are there. You don't have any business with them, but you have permitted them to be on the premises. So for them, in terms of what is expected of you by the law, you are supposed to warn them of concealed dangers or traps. You're also supposed to avoid the reckless or willful misconduct which will endanger them. Then we also have a person who enter as of right, like maybe statutory or public authorities, like the police, firemen, utility workers like ECG and so on. They are treated as lawful visitors so long as they act within their authority. So once they are there just to do their, what their office or their mandate entitled them to do, they are treated as lawful visitors. And for that matter, they are also supposed to be protected by the occupier. Then we have unlawful visitors, or what we call the trespassers. Those who are on the premises on the frolic of their own. They are not invited by anybody and they have no business with the occupier. So they are on the premises without consent or right of entry. So the old position of the law used to be that there's no duty on the part of the occupier except to avoid intentional or reckless harm. In other words, the occupier is not supposed to do any positive of care towards them. All that is expected of them is that the occupier is supposed to avoid, directly causing harm or reckless harm to them. But British Railway Board against everything in the early 70s, case law seemed to have changed the position that there's what we call the duty of common humanity, which is owed where the trespasser's presence is known or reasonably foreseeable. I mean, human beings, we all more or less owe one another, some responsibility when it comes to safety. So long as the occupier is aware that the trespassers on the premises, the law expects the occupier to extend the duty of common humanity to the trespasser. In other words, respect the fact that he's also a human being. So there are a number of the case law which illustrates. So just know one or two. What about child trespassers? Like a child, for example, is allured or attracted to come to your premises. The law imposes a higher duty of care on you, the occupier, particularly when the age of the child is considered, and also the foreseeability of allurement. In other words, can it be said that the occupier ought to have foreseen that there was something on the premises which will attract or excite the interest of the child to come onto the premises? And if the answer is yes, then the law imposes obligation on you to ensure that the child will be safe when he or she comes on the premises. What about rescuers and specialists? Well, I mean, it's not very much different from the others that we have discussed. Like when you say like a rescuer, for example, if there's a danger, right, happening on your premises, somebody is drowning, maybe you have a swimming pool, somebody is drowning, and the person is shouting, crying for help, and then you're passing by, and you decide to rush to, help. And let's suppose that you have a dangerous animals, maybe like you have a lion you keep as a pet in your house, and then you don't chain it, and then this person get there, and then the lion decides to chase him and start chewing part of his body. Or the occupier be held liable. So that is what we are trying to explain. So the allurement principle, let's say a few words about that. Uh, that is where something is attractive on the premises, but then there are dangerous conditions. And for that matter, despite the fact that the child might have come onto the premises as a trespasser, because of the attraction you have over there and associated danger, which you haven't taken any steps to mitigate or to protect the child against, the law will convert the child trespasser into an implied licensee, in which case you have an elevated duty or obligation to ensure the safety of the child. Are there any defenses available to occupiers when you are sued for occupiers liability? Well, let's say maybe warning if you have put in place necessary warning signs, which is sufficient to make visitors reasonably safe, then that can be a defense to you. And then the defense of voluntary non-fit injurer, if the visitor knowingly accepts risk. So the visitor is coming and he or she is made aware that there are this and that risks, and also knowingly comes there aware of the risks, still chooses to go there, then that could be a bit of a defense. The independent contractors, If the occupier can demonstrate that the particular victim of the tort is an independent contractor, it may absolve that the like the like the if the the immediate perpetrator of the tort, for which reason occupiers liability is being visited on the occupier, if he can demonstrate that he was an independent contractor, that may absolve liability if reasonable care was taken in selection and supervision. So that's what we need to focus on. If you have like a problem-based question, we need to identify the entrant type, the category of visitor, because the duty differs, as we have seen. And then, of course, we've talked about trespassers, children, allurement, special protection, contractual visitors. And you must also always look at the scope of the invitation, the area, the time, the purpose, as the case may be. So I gave this question. I mean, this is a made-up question, so nothing for you to worry about. Just made up to help you think, organize your points maybe together. So the guy, like as we indicated, the state is trying to do a legislation of personal liability, and you're supposed to submit a memo to the AG, highlighting one, the deficiencies in the present reliance on common law and case law principles. Two, categories of entrance and duty of care that should be codified by the statute. Three, the scope of occupiers' liability, including children, trespassers, rescuers, and public authorities. Four, the available defenses and remedy that should be included, and how the proposed statute should integrate with Ghana's customary law and public safety framework. So these are the things that you are supposed to do. And as you will notice, it's basically an attempt to more or less demonstrate your knowledge on how this particular area of the law has evolved and what are the problem areas and which area needs to be reformed. Will anybody attempt to take us through? Yes. Just feel free and then contribute. You are sleeping. Okay, if you are sleeping, let's all go and sleep.
My Lord, Emmanuel, before we come back to the question, sorry, just a step back on the liability of how do we call those in possession for that of children with respect to children or kids. There have been many common law cases where the court may say that there is some kind of contributory negligence from the case. Therefore, whatever being the cost awarded is large 50%
Okay.
to both the reason. I don't know if you could please throw
Okay,
highlight
so
on that.
okay, good. Contributory negligence as to good. So we are talking about the general the thought of negligence. So where you have set up a case of negligence that there's been a breach of duty of care, and then as a result of the breach of the duty of care, you've suffered injury. Now the tortfeasor or the defendant will also put up argument and say that you too, you contributed towards the the injury or the outcome. And for that matter, even if I am liable for negligence, I should not be made to bear the full consequence of the injury and your role with regards to whatever you did in letting the injury escalate and so on should be factored into making a determination as to how much of the compensation that I have paid, which should be reduced by your role. So that is a contributory negligence. And it depends upon the particular situation and then the facts. But I don't know if you want to say that whether for a child
Yeah, my lord,
trespass. Yeah.
respectfully, I'm asking with respect to the occupier's liability where there is a child involved,
Yes.
of which that child is not a lawful visitor.
Okay.
Um, Either there is a warning sign there or there's no warning sign there where
Yes.
the child entered there. We know under the exemptions, where particularly when it comes to the unlawful visitors, kids are exempted from that sometimes because where there are some dangers and there's no sign there, and then that kid cannot read or that child do not know that there's a danger, then was injured, there may be some kind of liability arising from that. And we've seen many common law cases of which they give 50% liability to the, how do we call it, the occupier. Reason being that there seems to be some kind of contribution negligence from the child or kid
No, you
because they
see,
are.
okay, I get your point. You see, if you go to, let's say, UK, and they have occupiers liability, legislation or an act, but we don't have. So when we are using uh, the foreign textbooks, we have to be careful not to import legislation which we don't yet have. UK, as far back as 1957, they have a legislation on occupiers liability. Okay, so let's come back to the question on the table.
That's my lord. If I may come in,
Yeah.
let me try making an attempt to see. So, as a legal research assistant or legal research officer who is writing, so of course my memorandum or my memo will have from my position, state my position as legal research officer of the Ministry of Justice, and then to the Honorable Attorney General. The subject matter will basically be key matters for proposed legislation on occupiers liability in Ghana. Insert my date there. My introduction will basically focus on the fact that my memo is setting out issues that should address the drafting of the legislation on the occupiers liability in Ghana. I need to mention the fact that currently this occupiers liability area is governed by the common law principles that we inherited from the English common law or the British laws that were colonizing us those days. And many of them, as a result of the absence of a major statute. There are sometimes where facts may differ in our jurisdiction compared to the British jurisdiction. Therefore, the application of those inherited English principles their application may have some challenges. And I will need to talk about some of the deficiencies or some of the challenges in the system currently. Mention of some of the uncertainty, particularly duty owed by the occupier when we are determining a case-by-case basis, leading to some level of unpredictability in the system. And then also the fact that the rules are found mainly on case law, which is not easily accessible to people who are not lawyers. I think it's also another thing that we need to look at. And then the inconsistencies in the application of those cases by the courts. There may be variation. Even sometimes when some cases may share the same fact, the court might not be applying them consistently. So there seems to be some kind of variation in the standard when it comes to the application. And then also mention the fact that there's therefore a clear gap that need to be set out. There's a need to set up a guideline since there's a clear gap there to have a standardized way of regulating the whole law of occupiers liability and some of the modern realities that may arise. For instance, where in commercial cases, for instance, you go to stadium currently, whatever that happened, for instance, in the I think Nottingham Forest versus I've forgotten the title of the case, but where the match, some family members, I mean, some of those principles that the common law court applied there, some of them might not be applicable in our system. There's therefore the need to legislate that. Then my memo will also focus on, I think I should think of the various categories of entrants and their duty of care that will be owned by the occupiers to those people. By mentioning of the those that are lawful visitors, like you mentioned, the unlawful visitors, and even the lawful visitors, I need to look at the invitees, people who may come to this place to come and do business. People who are licensed, for instance, you have some social guests that may come, people who are unaware of dangers when even though they are licensed to enter there. Then that of trespassers who may be under the unlawful visitors and even children who may fall under the unlawful visitors. However, so the children here, we may have those that may fall under lawful visitors and those that may fall under unlawful visitors. Reason being that, for instance, in a situation where a parent is a lawful visitor, walks in with his or her child, that child should be considered a lawful visitor. So any danger that arises or any injury that that child may suffer, the occupier should be held 100% liable for that. But in situations where the child is not a lawful visitor, but enter there should also be some proposal there as to what should be considered, whether it's going to be the common law system of that 50-50, like I asked the question earlier. And then also talk about the bill clarifying on the danger conditions, the category of buildings and structures that should be considered, and then if there is any defective or features that should be considered. And then also make available defenses as per the structure of the question or the requirement of the question. And then maybe finally talk about those remedies that may be available for those that may suffer injury or damages as a result of the injury they suffered. So I think that is how I'll go.
Yeah, I
And then
think Emmanuel, that was a very comprehensive response, and you're on the right track because a question like that actually is testing your knowledge of how well do you understand this particular area of the law, and are there any gaps or any problem areas regarding this law? As rightly said, they are heavily common law, and even if you look at the English law where you borrowed from, they have long made some legislative intervention. So that should tell us that the common law principle and then the case law may not all the time speak well into our situation. So there's a need for us to have our own tailor-made solution to address some of, and you've actually done it very well. You've actually done it very well. So you're on the right track. Yeah, so at this stage, I'm feeling sleepy, so we have to draw the curtain down. We'll continue in the course of the day. Have a good morning.
We are most grateful, my Lord. We do appreciate your efforts.
I'm grateful, my Lord.
most